This is an ex parte motion at this point. We'll hear first from the movant. Go ahead.
Yes, thank you, Your Honor. My name is Paige Benda and I represent Rachel. And just as a quick housekeeping matter, Your Honor, I do want to apologize to the court. There was a statement in my client's second declaration at 241 regarding mediation. My client was under the impression and it was my bad, because I was under the impression that Ms. Jensen was trying to invoke a mediation clause. So there is a reference to that at the beginning. Ms. Jensen has since clarified that, but my misunderstanding that then became my client's misunderstanding had to do not only with, I've assisted in family law for about 16 years now in the Southeast Judicial District. And so my understanding was that mediations were more permissive when there wasn't a motion for primary, but also because of the domestic violence in this case, there's actually a prohibition at NDCC 14-09.1-02 that when no mediation can be ordered if the visitation issue may involve physical abuse of a child, which I believe is what we have here. There doesn't need to be a definitive finding. It's just whether it may involve. So just all together there, Your Honor, I did just want to apologize. And just clarify that for index 241 and kind of how that came to be. But first, plaintiff does object to those hearsay portions in Jared's declaration, Mr. Bertelson's declaration, that would be at 231. And Ms. Kappas' declaration at 237. There's a lot of, it's a good portion of Ms. Kappas' declaration is actually almost written in transcript form. But Rachel does request that this court issue an interim order based upon the exceptional circumstances in this case, and they're two-pronged. There's the threat of imminent danger, and there's also circumstances here that indicate the ex parte order is necessary. Rachel and TJB's declarations have described the threat of imminent danger, but also it provides the court with the information demonstrating the circumstances that exist. And with the threat, in plaintiff's brief, 140929 parents 2 presumes imminent danger when there's a current domestic violence and a past incident of domestic violence involving a dangerous weapon. And that again, that's 140929 parents 2. And that is the presumption regarding a violent parent who does not have primary residential responsibility and that the court shall only allow supervised parenting time. And so Rachel and Tanner have submitted declarations to the court that outline the following facts. Jared drinks alcohol during his parenting time and it led to the abuse that's described in Rachel and TJB's declaration. Drinking alcohol during parenting time is prohibited by the party's judgment, and that's at index 194 at paragraph 9, parents G. Previously, the record demonstrates that Jared was ordered to use the sober link, and that's at index 84, paragraph 13. That was during the original divorce proceeding. And the declarations demonstrate, Your Honor, this is very important. It's not just merely the drinking alcohol in contravention of the judgment that leads to the threat of imminent danger. It's the abusive behaviors that accompany the alcohol use during parenting time that places the children in the imminent danger. Those behaviors included the threatening of violence to Tanner, telling him he would knock him out, beat his face in. That's at index 206, paragraph 8.
So I'm going to stop you right there and I'm going to ask you a question.
Yes.
So when we're talking about an ex parte order, at least subfactor A requires the court to consider imminent danger. What does imminent mean to you?
Likely to happen, and I believe that that's 140922-2. That's why it's presumed when, oh, sorry, Your Honor.
So likely to happen. Why was there a 2-month delay from the basis? So stop talking when I'm talking, right? You seem a little excited. You need to just wait.
Sorry.
So why was there a 2-month delay before the statements that you're claiming form the basis for an imminent danger to the child between the time that that allegedly occurred and the time that you filed your motion? How is that imminent when there's a 2-month delay in filing the motion?
Yes, Your Honor, just to address that, My client's first declaration demonstrates that Jared actually denied his parenting time, and then shortly before this was filed, started requesting parenting time again. And in my client's second declaration, and that is at index 241, my client talks about the fact that she was not only working with law enforcement, hoping that that would happen and court could be avoided, but also was hoping Jared would find some help for himself. And that's in her second declaration. And Your Honor, just to the extent that this needs to be noted, because this was in defendant's responsive brief that somehow kind of utilized her having current counsel as having anything to do with that. You'll see in the record, Your Honor, at index 198 is actually a service document from the state of North Dakota. That's their notice of being a real party in interest. And if you see who that was served on both Jared and Rachel as pro se parties, because the judgment at index 194 released the former counsel. And that's at paragraph 48. So that service document is dated August 21, 2025. And that demonstrates that at least on August 21, 2025, there were two pro se parties.
Okay, continue.
Okay.
If you have any other argument.
Yes. Thank you, Your Honor. Jared denies that he has made these threatening statements, but Your Honor, if you look at Exhibit C at Index 205, this is an adoptive admission where Jared failed to provide a denial when he was confronted with threatening TJB and saying the only thing you'll ever be good at is, I don't know if Your Honor wants me to say it on the live stream. And then Exhibit E at index number 403 demonstrates another adoptive admission by Jared, where he does not deny that he said he would beat the minor child's face in, was raising his fist, or even just being on top of him. And those are non-hearsay exhibits, Your Honor, including the statements preceding that under North Dakota Rule of Evidence 801 D2B. It's a statement offered against the opposing party, and it's one that he manifested or adopted to believe to be true. The texts demonstrate clearly set forth accusations, which a reasonable person could understand. Jared had the opportunity and he had the ability to reply. And as demonstrated by the exhibits, he did have that ability because he did reply.
Does he have an obligation to reply?
I would think that a reasonable person would deny those statements if they were not made.
Does he have an obligation? Does he have to deny every allegation that your client makes? Otherwise, it's considered an admission.
Your Honor, in this instance, we would argue that demonstrates an adoptive admission in the parent-child being confronted with those statements and just not responding, even though they were clearly set forth.
So that wasn't responsive to my question. Does he have an obligation to respond to every single allegation that your client makes? Otherwise, it's considered an admission.
Your Honor, to the extent that he would have to, respond to other things not involving actions and behaviors towards the child, I would say this is a situation where, under the judgment, the parents are to work together. They have joint decision-making responsibility. They're supposed to talk about these types of things. And I guess I would argue that a parent would have an obligation to, affirmatively respond or deny to those types of accusations.
Do you have any citation to law supporting that position?
No, Your Honor, just that they have the joint decision-making responsibility. So I think that it's just expected under having joint decision-making responsibility that they could have conversations about this. And so I think that's, just to answer Your Honor's question, I think that's where the reasonable expectation of responding would come in.
All right, anything else?
Yes, I would also note that, the other children are not unaffected by this domestic violence. And it's not just that first prong, Your Honor, of the imminent danger. And I understand that. I understand that there's a concern regarding the timing of the filing and waiting 2 months, but also that is, Jared kind of changing his tune on that. And then my client, as she said, in her declaration, she's just stuck in a terrible position, but there is the basis of just the circumstances indicating that it's necessary. And I think those circumstances have to do with what wasn't denied by Jared, what is attested to by TJB in the declaration, what is attested by my client of actually hearing. And the court has the power to, follow or to review the 1409, excuse me, Your Honor, has the power to review that 142209 2 and under 140929-2, and it provides that, if Jared has that prior act of domestic violence, and then if the court finds that, domestic violence as pursuant to Rachel and TJB's declaration as they set out, then the court shall only order supervised parenting time. And I think the other circumstances that demonstrate it's necessary are that those accusations have been made. Rachel heard those statements that Jared's now denying. And in order, as Rachel said, for the safety of all the children, it's necessary that a sober link provision be put into place.
All right, anything else?
Yes, just real quick, especially supporting circumstances that are necessary is the fact that Jared has failed to demonstrate by clear and convincing evidence that unsupervised parenting time with him would not endanger TJB's physical or emotional health. He didn't even deny that he was utilizing alcohol on August 9th. He just made specific denials that he wasn't drinking on the way home or when speaking with the deputy. If the court believes that Jared made these statements that were in TJB's declaration, of which my client said she overheard while on speakerphone, then Jared's refusal to even admit the same demonstrates the future danger to TJB's physical and emotional health. And it's also Jared failing to demonstrate by clear and convincing evidence how this behavior would change or how the children would be safe. So this just demonstrates an inability to safeguard TJB or the other minor children if there's no sober link provision, if there's no supervised parenting time. And, prior domestic violence with use of a dangerous weapon, the domestic violence perpetrated on August 9th, it included, a sexual statement made to the child that was described in TJB's and Rachel's declaration. So to be clear, this isn't something that TJB is just saying as a 14-year-old child. My client overheard those statements. She overheard the beat your face in, the sexual statement. And in accordance with 140929 parents 2, the court should allow only supervised visitation with TJB. But because Jared's response that was just a blanket denial, despite my client witnessing those statements, the court should implement the sober link requirement for Jared's parenting time until further order of the court, of the court. And thank you, Your Honor. That's all I have. And I apologize for interrupting you before, Your Honor. I didn't mean to.
Thank you. Ms. Jensen.
Thank you, Your Honor. Just a couple of housekeeping matters before I get into my argument. First and foremost, Your Honor, is TJB available today? I'm unsure if he is at Ms. Benda's office or not.
Ms. Benda?
Yes, he's very far away, but he is here. He is far away from the hearing. He's across the office in a separate conference room so that he can't hear anything.
Thank you, Your Honor. With respect to Ms. Benda's assertion that Mr. Bertelsen has made some sort of an adoptive admission by not responding to Ms. Wallender's allegations, I'm significantly concerned because I think that creates a very slippery slope, especially when you have a very high conflict family law matter where if Mr. Bertelsen would have denied making those statements, then what happens? The parties just continue to argue about who's being truthful and who's denying them and whether or not that's an admission or not. Additionally, Your Honor, I don't believe that there's any case law supporting Ms. Benda's contention. So I would ask that the court take Mr. Bertelson's failure to respond or willful decision to not respond to Ms. Wallender's allegations that he made those statements with the weight that it deems appropriate. With respect, Your Honor, to 140929 sub 2, I'm looking at that provision of the statute right now, and I do not believe that it has any application to the situation before the court. That section specifically states that if the court finds that a parent has perpetrated domestic violence and that parent does not have residential responsibility, and there exists one incident of domestic violence which resulted in serious bodily injury or involved the use of a dangerous weapon, or there exists a pattern of domestic violence within a reasonable time proximate to the proceeding, the court shall allow only supervised parenting time with that parent unless there is a showing by clear and convincing evidence that unsupervised parenting time would not endanger the child's physical or emotional health. Now, I'm sure the court is concerned, as is every individual involved in family law, that there's going to be some potential for future domestic violence or whatever it may be. However, that statute and Ms. Wallender has not, I guess, put forth the evidence necessary to even indicate that that portion of the statute is even applicable to this situation. Therefore, Your Honor, I would ask that the court not even consider that part of the statute with the facts before it.
Guys, today we dive into a tense custody hearing where the mother's attorney warns of violence, alcohol, and fear.
Now, Your Honor, our concern with this motion for ex parte interim order is that it quite clearly does not rise to the level as articulated in Rule 8.2. Rule 8.2a, as the court noted, requires exceptional circumstances, which means that there needs to be an imminent danger to the minor child or circumstances indicating that an ex parte order is necessary. And I've more clearly and more discussion outlined the actual rule in my brief, so I won't repeat it. But suffice it to say, Your Honor, that it's our position that plaintiff's motion should be denied in its entirety because it fails to meet those stringent requirements. First and foremost, Your Honor, Ms. Wallender's declaration should ultimately be excluded. She lacks a large amount of firsthand knowledge concerning what actually happened that day, and her entirety, almost the entirety of her entire declaration, is based upon inadmissible hearsay from TJB. She was not present. She did not observe any of Mr. Bertelson's behavior, her son's behavior, or frankly, anything that occurred between TJB, Mr. Bertelson, Ms. Kappas, and her entire extended family, and the party's other minor children that were also present. Ms. Wallender's firsthand information, Your Honor, is limited to the very short period of time that she showed up to Mr. Bertelson's house when law enforcement was present to pick up TJB and a few of his belongings. That is the only competent testimony that Ms. Wallender actually provides in her declaration. Therefore, we don't think the court should even consider it. More importantly, as the court touched on, is the timing of this motion for ex parte interim order. 2 months was waited until someone brought this motion for ex parte interim order. There's no reason, there's no basis or explanation as to why there was such a significant delay. Even if there was, Your Honor, the simple fact that someone waited 2 months to bring this motion demonstrates that there's not imminent danger. There's not a concern or a circumstance necessitating the issuance of an ex parte interim order. Now, Your Honor, even if the court would consider Ms. Wallender's declaration and considered Ms. TJB's declaration, there's a complete failure to demonstrate exceptional circumstances exist to grant her motion for ex parte interim order. The declaration of TJB, Your Honor, is that of a 14-year-old teenager. It paints a very one-sided story accusing Mr. Bertelson of yelling and screaming and acting out of control for, if you look at Tanner TJB's declaration, for no reason. It doesn't provide a basis for Mr. Bertelson's behavior. TJB completely leaves out that part of the story, which Mr. Bertelson and Ms. Kappas, who were also present at this event or this incident, explained in detail in their declarations. The declaration of TJB, again, written by a 14-year-old, and is clearly drafted with the intent to minimize the situation and to reduce any blowback he may get out of this situation because of his attitude and his behavior that day. Additionally, Your Honor, there are significant concerns with TJB's veracity, maturity, and who wrote his declaration. If the court reviews his declaration, it comes from a very mature voice, and again, takes away a lot of, it minimizes a lot of his behavior that he participated in that day. Ms. Wallander and TJB also failed to disclose to the court that he has a history of acting out and has had a similar situation occur at Ms. Wallander's home, which Mr. Bertelsen provided the court with information pertaining to that. In that specific situation, TJB actually accused Ms. Wallander's husband of putting his hands on his neck or strangling him during an altercation where TJB was again acting out and Mr. Bertelsen's brother had to go over and diffuse the situation. Regardless of what occurred at Ms. Wallander's home, there is a serious concern with TJB's veracity and maturity in this situation and his ability to be entirely truthful. More telling, Your Honor, is the fact that the allegation concerning the incident on October 9th, TJB has continued to text Mr. Bertelsen and request to come to his property to go hunting. Mr. Bertelsen has responded and explained to TJB that they need to sit down and discuss the incident from 2 months ago and navigate a path moving forward to repair their relationship. TJB has indicated a resistance to this plan, but even as recent as last week, Your Honor, he was texting his father asking him if he and a friend could come to the house and go hunting on Mr. Bertelsen's land. In fact, on one occasion when TJB texts Mr. Bertelsen, TJB responded in a very defiant manner and said, "You don't even own this property. Here's the Zillow listing, so I can come and go hunting if I want to." This continued contact and the statements that the conversations that Mr. Bertelsen and TJB have in these text messages do not indicate that TJB is scared of his father or feels as though he's in danger. He is a defiant 14-year-old that is clearly upset at his father for setting boundaries and trying to parent him. He's not scared of him. The incident on August 9th, while obviously regrettable for those involved because it involved conflict in law enforcement and that's uncomfortable for everyone, it's nothing more than an attempt of a parent to try and diffuse a very difficult situation with a very defiant 14-year-old. Again, Your Honor, even if the court considered the declarations, there are no exceptional circumstances justifying the issuance of an ex parte interim order. Lastly, Your Honor, Ms. Wallander, in her request, she wants significant restrictions be placed on Mr. Bertelsen's parenting time, and there's no justification. In Kita, the case I cited, Your Honor, in my brief, the Supreme Court stated that a restriction on parenting time must be supported by a preponderance of the evidence and accompanied by a detailed demonstration of the physical or emotional harm likely to result from the visitation. There's a simple request that Mr. Bertelsen's time be limited to supervised time and a significant reduction in his time happen, and he be required to submit to sober link testing. There's no detailed demonstration, there's no detailed explanation of the physical or emotional harm that would likely occur from parenting time between TJB and Mr. Bertelsen. Clearly, Your Honor, if Ms. Wallander were actually concerned with whether or not her son was in danger, she would not allow her son to continue texting Mr. Bertelsen and trying to go out there and go hunting. Rule 8.2 sets a very high standard, Your Honor, and it's for a reason. It is to protect individuals like Mr. Bertelsen from having their parenting time suspended or reduced for a reason that does not justify exceptional circumstances. The circumstances here simply do not rise to that level, and an ex parte interim order should not be issued. We respectfully request that the court deny plaintiff's motion for ex parte interim order, Your Honor.
All right, thank you. Ms. Benda, as the movement, I'll give you an opportunity to rebut if you would like, and then I'll issue my ruling on the ex parte request.
Yes, Your Honor, I just wanted to respond to the 140929 parents 2. More guidance on that is actually found in O'Hara v. Schneider, and that's 2017 ND 5321. And as far as the adopted admissions, the guidance for that can be found in Star v. Morset, and that's 236 NW 2D 183 and 190. And another thing I just really want to make clear is defendant continues to argue that Rachel has no personal knowledge of these and of this incident. And Rachel has very important personal knowledge, and that is that she heard the commotion, she heard the physical commotion, she heard the statement, the beat TJB's face in, and she also heard the sexual statement that I probably don't have to repeat. And so these items are not hearsay. A defendant continues to say that, but Rachel has personal knowledge. It's admitted that Rachel wasn't there, you know, before that phone call was made to her where she heard what Jared was saying. She was there, and the imminent danger, the fact that he has not been back for parenting time, which I want to make clear, my client knows she has to follow the judgment. This isn't my client not following the judgment. Defendant made a comment that my client could just interfere with phone calls and texting Jared, and my client would not do that, and my client could not do that because that would be against the party's judgment. And also, defendant made a comment that Rachel somehow was hiding any past issues that TJB has had. In my client's very first declaration at Index 202, she went through the history. She told the court about the former admission to Prairie. There, you know, this is in there, and she said she's not denying that these issues are there. It's not about, and Your Honor, I'll just close with this. This isn't about 14-year-old's behavior. This is about Jared's reaction to that alleged behavior. And thank you very much, Your Honor, but we would request that an ex parte order be issued that would limit the parenting time with TJB to supervised and would put in a sober link provision to keep all of the children safe. Thank you, Your Honor.
All right, just for the record, the court has reviewed the file, reviewed the declarations filed in support of the motion for ex parte interim order, and the declarations filed in opposition to that ex parte interim order. Court notes that, frankly, all of the documents contain inadmissible statements, inadmissible declarations. I'm not going to walk through each declaration and lay out what I find inadmissible, frankly, because I don't think it's necessary for purposes of the court's decision, and neither party asked me to do that. Based on what the court finds admissible and competent, court turns to Rule 8.2, the North Dakota Rules of Court. 8.2a says that no interim order may be issued except on notice and hearing unless the court specifically finds exceptional circumstances. Exceptional circumstances include a threat of imminent danger to any party or minor child of the party, or circumstances indicating that an ex parte interim order is necessary to protect the parties, any minor children of the parties, or the marital estate. Here, addressing the low-hanging fruit, neither party alleged any circumstances necessitating an ex parte interim order concerning the marital estate or safety of the parties. The sole allegation here is a threat of imminent danger or circumstances indicating that an order would be necessary to protect the party's minor child or children. So the other components are inapplicable. 8.2 again continues and requires specific facts outlined in a declaration It requires good cause to be shown before the issuance of any order. Here the court, as perhaps evidenced by its questions, I am concerned about the imminence of any threat or danger to any party. In light of the substantial delay between the alleged incident, and I say alleged because at this point there's declarations, the court's considered the declarations, but they have not been subject to cross-examination. So the court takes them for the value that they're worth at this point, which is uncontested declarations. I am concerned about the imminence, considering the substantial delay between the alleged incident and the filing of the motion. The court notes that there are text messages and allegations concerning contact by TJB and Mr. Bertelson, demonstrating a lack of fear. Again, exceptional circumstances to the court. That means that the circumstances need to be exceptional, not the ordinary case, especially when we're talking about a high conflict, high litigated divorce and parenting responsibility matter. Court notes that exceptional circumstances, the court finds that exceptional circumstances don't apply in this case at this time. And the court finds a lack of imminent danger. At this point, the court finds any potential danger or circumstances to be speculative to future visitation rather than applicable to past situations, the past alleged situation. So at this point, I'm going to deny the request for an ex parte interim order. That does not mean that I will not enter an interim order after a full hearing. It just means that the traditional process needs to be followed in this case. The rule requires that the moving party seeking an interim order secure a date and time for a hearing to be held within 30 days of the motion, rather than having the movant. I'm assuming that the plaintiff or the movant still wants to proceed with the request for an interim order consistent with the motion. We'll have full hearing on the matter if requested. The dates I have available that are more than 21 days from the date of the motion being filed, but less than 30 days from the date the motion was filed are very limited, in part because I wasn't the assigned judge when the motion was filed. And there was a delay in today's action as a result of the reassignment and the recusal of Judge Cruff. I have 2 available dates for that motion hearing. I'm going to give it to the parties and leave it up to you whether you, A, want to have the interim motion hearing, and B, which date you would prefer. The dates I have available: November 3, either in the morning or in the afternoon in the law enforcement courtroom in Richland County, or November 5, either in the morning or afternoon in the law enforcement courtroom in Richland County. So that's November 3, a.m. or p.m., or November 5, a.m. or p.m. Ms. Berta, as the moving party, your preference.
Yes, Your Honor, plaintiff would like to move forward with that, and November 3rd, either morning or afternoon would work. As would November 5th, morning or afternoon,
All right,
just in
thank you.
case that works out for Ms. Jensen better.
Ms. Jensen, do you have a preference?
Your Honor, actually, I'm sorry, but neither of those dates work for me. I have a mediation scheduled on November 5th, and then I'm in 2 separate hearings on November 3rd. Additionally, Your Honor, I've never handled it. I've never had an ex parte interim order turn into a motion for interim order. Because they do have 2 different standards. So the ex parte is based upon, obviously the imminent and exceptional circumstances, but an interim order is based upon the best interest factors, which Ms. Wallander has not gone through in her declaration. And there isn't an alternative motion for interim order. So I would object to this being placed on as a motion for interim order under subsection B. She does have a motion to amend judgment pending as well, Your Honor, and we just received a referral to the family mediation program. So additionally, I think that it would be duplicative to have this set on as a motion for interim order when the motion to amend judgment, if they don't settle, will also go to hearing. Largely, I mean, I assume will allege the same facts.
Oh, Your Honor, may I respond?
Yes.
I was just going to say that the declaration that is filed does talk about almost every single factor of the best interests of the children, the facts that are provided to the court, allow the court to make a determination based upon the best interests. And so my assertion is that it is more than perfunctory parroting. You know, it is providing the court with information in which it can make its assessment. Thank you, Your Honor.
Judge, may I also point out that this was only noticed as an 8.2A motion? There's no citation to 8.2B in the notice, the motion, the brief, nothing, Your Honor. This was clearly meant to simply be an ex parte motion. And now that the court has denied that, I would request we just proceed on the motion to amend judgment.
I'm sorry, Your Honor. Can I respond?
Briefly.
I believe that the court would have discretion, you know, out of judicial convenience. There's a 3.2 motion pending, but there's gonna, you know, plaintiff needs something in the interim. So if we could, I think it'd be a waste of judicial resources to have to reserve everything again to be put in the same position. But if that's what Ms. Jensen would like us to do, we're certainly able to do that. But I do think that the court has the ability to waive that and set this for hearing.
All right. So here's what I'm going to do. I traditionally, when I've denied ex parte motions, and I don't grant them often, I have traditionally, as I did here, explained to the parties that if you want a full hearing, I'll have a full hearing subject to cross-examination. And I try to abide by that 30-day requirement as closely as possible, although sometimes it's not possible. Here, Ms. Jensen has objected to that procedure. And the movement, although making an argument that that procedurally could be waived, appears to concede that she will reserve the motion for interim order if necessary. With that being said, here's what we will do. I am going to, again, deny the ex parte interim order request. If Rachel wants to proceed with an interim order request, she may do so, but she must serve and file notice and comply with Rule 8.2. I understand that might become duplicative, but nevertheless, procedurally, if that's what Ms. Jensen wants, that 30-day timeline won't start. That 21 to 30-day timeline won't start until service of an updated motion. So at this point, I'm not going to take any action. We won't schedule the further hearing date. The move-in will need to secure a time for the hearing and comply with the rule. We'll proceed that way if the motion is indeed filed. If not, we'll just proceed on the motion to amend residential responsibility from there. Any questions from either party?
I do have just one, Your Honor. Just to avoid any potential objection later, just wanted to let you know that it would be plaintiff's intention to, if plaintiff is going to have to do an actual, 8.2B interim motion, there is going to be an updated declaration and the documents may be different. So I had noted duplicate documents, but if we're starting from scratch and Rachel starting, from the beginning with an interim motion, I just wanted to make sure that that was okay with the court, that it would be a new interim motion.
I understand it's going to be a new interim motion. I understand that evidence by way of the interim motion is submitted by way of declaration according to the rule, subject to the right of cross-examination. I am going to tell the parties, you get one shot. So essentially, you're going to follow the rules. I'm not going to allow multiple rounds of declarations to be filed. So you'll have one opportunity as the movant to file the motion and declarations you believe support it. There'll be a responsive period, and then there'll be a reply period as outlined in the rules. But I don't want to see 7 declarations filed by the same person on one side and 8 declarations filed by the opposing party. That becomes counterproductive. You are going to have an opportunity to cross-examine any declarant, assuming that you filed the demand for cross-examination. But these motions are intended to be decided largely on paper. And with one round of declarations, the rule doesn't contemplate multiple rounds of declarations and counter declarations. So I'm putting that out there now. Some of these files, I end up with 30 or 40 declarations. And I know both attorneys have undoubtedly came across that type of litigation. I generally don't tolerate that. So now both parties understand my expectations. Please follow the procedural rules, and we will take it up when it comes before the court and is properly ripe for consideration. Anything else from either party?
No, Your Honor.
No, Your Honor. Thank you.
All right, with that, we are adjourned. Have a good day.
Thank you, Judge.
Thank you, Your Honor.
The defense takes its turn, and the energy shifts fast. The father's attorney fires back with precision, calling the story one-sided and driven by hearsay. She paints the son as defiant, not fearful, and insists this is discipline twisted into drama. The judge lays it all out. No emergency order, no shortcuts, just due process ahead. Both sides stand silent as the decision lands heavy, leaving the future uncertain and the tension unresolved. Thanks for watching. Don't forget to like the video, subscribe to the channel, and we'll see you in the next one.